recently, I'll go through it in a bit. We just recently heard at 1:30 the Premier come on TV and make an announcement with respect to the gradual reopening of parts of the province of Ontario, which included golf courses. We'll get into that in a bit. I'm going to go over the legislation. But what I want to focus on today in the next 55 minutes or so is really what some of the issues that are going to arise from returning people to work, because it's a different world, and there's also legal obligations with respect to bringing people back to work, concerns health and safety. So the big question has always been up till now, when do we get to play golf? One of my favorite holes from Scarborough, which is the 4th hole down a valley. I love that hole. I think it's one of the few that I actually shoot well on. And really what I wanted to focus on today are these agenda items. So where we are right now in terms of both statistics and the government response, and then assessing. I'll go a little bit over that. Given the news, we're not going to spend too much time on that. I really want to focus on a recall to work, the process, and the health and safety obligations, because that's really where the rubber's going to hit the road. Most employers and most people who are bringing employees back to work are going to face challenges with respect to people coming back to work, both ensuring that the communication is proper, they're recalled appropriately, the legal challenges with respect to people who've been on layoff, and then most importantly, health and safety. That's what I want to focus on, and we can take some questions down the road if you want to do that as well. And particularly on the health and safety, you're going to see the obligations, guidelines, and how to deal with work refusals. I will tell you right now, we're getting a lot of employers who are getting employees saying, look, I know you're recalling me to work. I don't want to come back to work. I don't think it's safe, or I live with somebody who's vulnerable, and I don't want to expose myself to risk. And there's going to be responses to that and ways to dealing with it without simply saying that you're fired, which I think is the way that we have to avoid right now. Nobody wants to be the poster child for terminating somebody who said they didn't want to come into work because of COVID, but we'll deal with that. So in terms of where we're at right now, there are really, we're probably well over 6 million people who are not working and could be expected to return to work. And they had an attachment to a specific job. So it's not like people were unemployed and just weren't working. There are people who were able-bodied and working and had a specific job and could not return to work. So the statistics, both from an economic and financial, and just a social perspective, are quite staggering. The unfreezing, the thawing of the province is going to start to bring those people back to work. The workplace may not look the same. It may look different because there may be fewer employees. It might be more efficient. In your industry, I suspect that the numbers are going to be relatively the same, because generally you can't work from home. We're going to see in many other, like in my industry, people may be working from home more. There may be less staff required. So that's something we're going to have to all figure it out. This was the framework: stage 1, stage 2, and stage 3. Each is dependent on the chief medical officer's advice. All right, and so as they continue, we're at stage 1 right now, which is select workplaces allowing some small gatherings. Stage 2 and stage 3 will come down the road. The people that I've spoken with who are connected with the government have indicated that they think that sometime by kind of mid-June to late June, they're going to the phasing should be well on its way. I don't know whether or not I can say it's complete, but it should be well on its way. That doesn't mean that precautions and restrictions won't be in place. It just means that they're going to gradually open it up more and more to more businesses and employees returning to work, and businesses who are allowed to open without being a violation of the law if they're not a deemed essential service. Now, as you know, golf courses were not considered an essential service, but they were allowed under 2.2 of the Essential Services Regulation to prepare the golf course to be reopened, but only for the purposes of preparing and not for play. We now know, as of 1:30 this afternoon, talk about a timely webinar, that golf courses can now reopen at 12:01 at 12 o'clock on a.m. on Saturday, which means that golf on Saturdays, Sunday, and the long weekend is possible. I'm sure that had something to do with Ford wanting to golf, but it's a good thing for the golf industry, and I think it's a necessary thing, particularly given that the courses have been kind of being prepared for opening. So that's the law. That's where the government says you can do it. we're going to have to be aware. I'm going to give you a couple of comments on a framework of things, which means that if we get on a daily, weekly, monthly basis, people who test positive at the workplace, we're going to have to deal with it as employers. The government may step in if they think there's a problem in terms of a spread. As you've heard the government say, they have numbers, they have testing now that's fully up and running, and they have tracing. So if there are COVID instances in the workplace, I think we're going to report those to the government to ensure that they are allowed, that they can get in, trace, and follow up with respect to that individual circumstance. So the staffing requirements before you come back, which you've already done, really is, access the ground crew, common areas. I can tell you from my personal knowledge of how golf courses in the States and even mine in Canada are working, it really is going to be a matter of you show up, there's no clubhouse activity, you're not lingering, you're off. I'm sure that they will stagger tee times more than they normally have. I'm sure that they will limit the amount of people who can play in a group, and I'm sure that they will stress social distancing for the participants in the golf game, both before, prior, and after the round. So sitting on the veranda for a drink after your golf game is probably not in the cards right now, but we'll have to see exactly how the government reacts. But for right now, golfing is permitted. I think the question as to whether or not courses will open up their clubhouses and make them accessible is going to be another story. And that's one thing that I'd like to drill down in the government regulation to see what that means, because I'm not sure that I am completely sure at this point whether opening a golf course means opening the facility and the clubhouse facility and everything else. So we know the timing now. We know what the decision is. I think a lot is going to be dependent on how we want to address this. So let's talk about recall, because this really is an issue for most golf courses now. We've had people sitting out there, and I do know that most golf courses, I've done work in the golf industry for a number of courses and individuals who own a number of courses. And I do know that a lot of the workforce is seasonal. It certainly is in clubhouse facilities, but it's seasonal workforce, that people who are usually hired in March sometime and are kind of laid off from October until early March. So you're going to be recalling seasonal workers back, or you might have people who have been on full-time employment and are being recalled back to work, or were recalled but laid off as a result of the COVID crisis. So just to be clear, I'm going to give you the law on this, and I don't expect you to remember all of this, but in Canada, we are what's called a common law jurisdiction, which means that we have statutes, we have regulations, we have law on the books, in this case, the Employment Standards Act, which provides minimum entitlements at law. Common law is the much greater entitlement for individuals, but we don't need to talk about that here. But under the Employment Standards Act, you are permitted to lay people off. At common law, unless there's a provision in the contract that says you can lay off somebody's employment if they're non-unionized, then you can't officially lay them off at common law, or they can sue you for constructive dismissal. However, those damages would be limited until the time then you recall them to work. So the Employment Standards Act says it's legal to lay somebody off for 13 of 20 weeks or 35 of 52 if you've continued the benefits or hit any one of those bullet points. And generally, the way employers do it is they lay off, they say, we're going to continue your benefits, and then it's not until 35 of 52 that the Employment Standards Act deems that there's been a termination of employment. Now, that doesn't mean that the employee needs to take that position. It means that they can demand entitlement to their termination pay and severance pay under the legislation, which means you have to pay it at that point. So those are the numbers with respect to employment standards and when that happens. Now, after 35 to 52 week period, what happens is the termination date is backdated to the original day of layoff. So if you've had somebody laid off for 36, 37 weeks or 35 weeks, just as you approach it, the actual date of termination for employment standards purposes is going to be the first day of layoff. And that's what would effectively the Employment Standards Act would look at. Your ROE would indicate when you laid them off, what the day of layoff was, and if it was a termination as a result, the new day of termination. If you're recalling them from layoff and they've been on benefits, they are under an obligation to inform Service Canada of the fact that they've been recalled back to work. There are abilities under both the CERB and employment insurance to make income during a period of unemployment. while you're getting employment insurance benefits, but it is it's a dollar for dollar up to a maximum. So employees who are being recalled to work can no longer receive benefits, although the way the government is working the benefits and the cutback, they can still make some money during that period. So when we're recalling employees back to work, it should be in writing to their last known address. And you guys have probably done a lot of this because you're already preparing. But for those employees who have not come back to work despite being told, there's case law at the labor board that talks about giving them 30 days. But what I usually advise clients is to communicate them again, saying, look, we're calling you to work again to your regular job or whatever the job is. If it's not the regular job, it may be a bit more complicated. But I think you need to advise them that if they don't attend on the second warning by a date and a time, that they will be deemed to have abandoned their employment, and that could lead to, and that would be a termination of their employment. Here's the rub. If they can't come back to work because they are concerned about COVID, in other words, they have somebody who's at risk at home, or if they need family accommodation because the schools are not open and their kids are at home, or they have child care or elder care, that may trigger an obligation under the Employment Standards Act or under the Human Rights Code to accommodate that request. So if somebody says, look, I would love to come to work, I'm looking after kids here because there's no school and no daycare, then you're gonna have to look at that as an accommodation, all right, rather than just saying you can't come to work, you're terminated. Now, let me get into that a little bit more about when employees are coming back to work. You can ask employees if they've been tested positive for COVID. There is a privacy concern here, but you're not releasing to anybody medical information that they've provided you. What you're doing is for the purposes of health and safety, you're saying we need you to advise if you've tested positive because we can't have you at work, okay? You can also ask if they've come into contact with others. And many employers, including my own, we've done as a partnership to all of our employees a sheet that has asked these questions. Were you in contact? Were you living with somebody who's tested positive, who's just returned from travel? All of that. All of the good practices we've had up till now, if you've got symptoms, employees need to stay home. They can't come to work. We don't want them at work, okay? If they're sick, they get short-term disability. They can apply for that under your policy, or they can, if you don't have disability benefits, they can go on EI disability. They're not going to be likely to do the CERB and the EI at the same time. We can require them to self-isolate, although we can't really determine what they do at home, but we can tell them that for a period of time, we don't want them back to work until such time as they're symptom-free. I'm going to talk a little bit about whether or not there's compensation for that. If they're on sick leave, you've got that covered. If they're on EI benefits, that might do it. But if they're just saying I'm not coming to work because I'm living with somebody or I have childcare needs or I've got concerns, then we're going to have to deal with that, and I'll deal with that in a second. And keep records of all contact. Time, date, place, text messages, emails, phone calls. Have it on file. Keep it. We may never need it, and we probably won't. Just make sure you keep it. All right. I want to have that available in the event that somebody down the road says, you never called me, I didn't know, now you've terminated me, I'm going to sue you for wrongful dismissal. So those are all really good points to think about when you're dealing with recall. Now, when it comes to disclosure, all right, be limited about it. If people tell you that they've got a COVID issue, then take the nature of it, what they've disclosed, that should be put in a separate file, not distributed to anybody else. Okay? There is an issue of whether or not you have to report it to WSIB and file a Form 7 if somebody gets it. The problem is determining if they got it at work or not, because there's really no way to tell if they've contracted the disease at work unless somebody at work had it, you didn't tell them about it, or they had it in the same proximity that day and they came down with it. In which case, there might be an obligation. But for now, most employers are saying, like, unless I know that it was contracted at work, I'm not going to report it as a WSIB injury, but it should be reported to the government of Ontario so they can trace. All right. And there is a piece of legislation that came into effect early on in the COVID emergency, the pandemic, is Bill 186, which is an amendment to the Employment Standards Act and provides job protected leaves to those employees who are being impacted by by COVID. Now, that means you can get an unpaid leave. I want to be really clear about this because there are a lot of employees who are getting bad advice about what they can do by saying, I don't want to come into work. In order to get the unpaid leave and be free from reprisal or discipline for not coming into work, you have to fall into one of these categories. You have to be under medical investigation or supervision or treatment, in which case that's going to be simple. Under an order under the Health Protection Act, so in other words, that the business has been told that it can't operate or they can't go. Under quarantine or isolation, or under an employee-directed quarantine, or they're providing care or support to any one of the defined groups of individuals. All right, and that can be any wide group, and it's broadly defined in terms of family. So if somebody or somebody who comes back from traveling, although that's less and less the case now since the borders have been effectively shut down. So what that means is somebody says, I can't come to work because I have an elderly person living with me. I have a child living with me. In my case, for example, our youngest son, who's always been a high-level athlete, does get kind of respiratory issues when he gets infections. So I'm very careful about that because if I bring COVID home, it might affect him disproportionately. That might be the case and the concern of a lot of individuals who are living particularly with older members of their family. If that's the case, that's fine. You cannot discipline or reprise in any way as a result of their refusal to come into work, but that's an unpaid leave. All right, that means that they can take time off on an unpaid basis. All right, if they want to use vacation, whatever it is, but it's not something you have to pay them to do. But they have to fall into one of those categories, and that's an important distinction. If they don't, it doesn't fall under Bill 186. Now, when we talk about accommodation, I just want to highlight this again because I think this is one of the issues that's really been coming up in the last 6 to 8 weeks amongst most of my clients, both some who are essential services and have been working, and others who are not and have been just trying to keep up and determine when they get back to work or managing their workforce when they from home. And what it means is that if people have caregiving, it means that the Human Rights Code means you cannot discriminate on a prohibited ground of discrimination. Family status accommodation is considered a prohibited ground of discrimination and includes those areas of care that I talked about before, elder care, child care, right? You have to accommodate to the duty of undue hardship, which is a very high standard, which means if somebody says, I can't come to work because I'm looking after kids, it's okay to ask some questions. You can respect that decision on an unpaid leave basis. It's okay to ask questions, and you can also try to figure out whether there's something you can do to assist them, how long they believe that's going to be, whether there are other methods or options that they've looked into with respect to childcare, all of those things. But rest assured that a lot of employees are going to want to come back to work because, quite frankly, they need the money. But this human rights obligation applies to all employees in the province of Ontario and across Canada. It can't be contracted out of, all right? And it includes things like attitudes, discrimination, harassment, negative environment, systemic discrimination. So if somebody feels that they've been singled out as a result of their position with respect to COVID or the fact that they're sick, that can be problematic for the employer. But that gives you a sense of the accommodation requirement on coming back to work. So that's the first kind of overview when it comes to recall and a return to work. Let's talk now about the Occupational Health and Safety Act. Now, for most of you, you're already aware that the Occupational Health and Safety Act of Ontario, and there is similar legislation both federally and in every province and territory in Canada, sets out the obligations of employers with respect to their employees and ensuring that there is a safe workplace. So the example that I use, and here are some of the general points when it comes to health and safety. It's a broad obligation to provide a healthy and safe work environment and take every reasonable precaution in the circumstances for the protection of a worker. All right, that means, let me put this in maybe an easier format. It was generally developed for manufacturing facilities, but it applies to every workplace generally in Ontario right now. And what it means is if you worked for General Motors, all right, and there was a machine that didn't have a guard or a guide on it, right? The Ministry of Labor could come in and say, you got to put a guide on or you can't use the machine. An employee can say, I don't want to work on that machine unless the guide is there because I think it's unsafe, right? What that means is the legislation and the regulations, which there are industry-specific legislation for construction and so forth, all right, means that the employers owe a duty to the employees to ensure that there's a both a healthy and safe work environment to return to. It could be any hazard at the workplace. COVID is deemed to be a hazard, all right? So what we're seeing is this is something which we can't see, but there's still an obligation on employers to ensure that the workplace is healthy and safe, all right? Even though you don't know that it doesn't exist. It's not like having a manhole cover that you could put a fence around to say don't step in it, or warn people about and ensure all the proper precautions are taken. This is a lot harder. So I'm gonna explain to you how you defend yourself honestly, and that's a due diligence defense, which means that you've taken all reasonable steps to avoid a bad thing from happening. All right, but you have to show that foreseeable concerns were identified and addressed responsibly. The hole in the ground, that you saw it, that you put a fence around it, that you put a warning sign, that you told employees that there was a hole in the ground. I can tell you I've dealt with accidents at golf courses where an individual has been rolled over on a golf on a lawnmower, a riding golf mower. In one case, the individual was killed. We believe, and it was later proven, that he had a heart attack while he was driving the machine. But that was one of the instances where we had to show that all training records, all instances where the individual was given the right policies, procedurals, manuals, where we understood that all the original equipment was on the machine, it wasn't modified. All of those things went towards providing a due diligence defense, and it was very successful, because the golf course was able to say, look, we took all the precautions. We taught that person how to ride. We made sure the equipment was safe. And this was an accident which was in part, we think, governed by employee error or an unforeseen circumstance. But you have to balance that you've taken all reasonable steps, okay? The bigger the accident, the more serious, the higher the threshold when it comes to due diligence. So that means that all of your policies, and we're going to talk about those in a second, the back to work policies, the personal protective equipment, the social distancing, the hand washing, all of that needs to be in place just as if you're operating any machine on a premises. They need to be trained. They need to understand. You need to make sure that they've read, understand, and will abide by those policies as you go through. When you're talking about compliance under the Occupational Health and Safety Act, there are really 5 steps, 4, but one is you keep doing it over and over and over again. That's to identify, assess, and address risks, to have clear written policies with respect to the potential dangers, to make sure that the employees are sufficiently trained in advance to understand the dangers, and to supervise and monitor and deal with any violations of the training policies and procedures, and then do it all over again. It's an ongoing thing. So when we're looking at identify, address risks, we're going to keep updating information. So we have the information from the government. We know what they've said. We know the health information from the government. So we're going to take provincial direction for provincial and health authorities. If your facility has a joint health and safety committee, I would involve them, and I would bring them all in on the precautions, on the policies, on the training that's taking place. I would make sure that that all occurs. And that way you can show somebody down the road, if anything happens, that you've identified, assessed, and addressed the risks specifically at your workplace. The written policies and procedures, you're going to have a lot of those that you have every year when people come back to work. You're going to invoke all of those, but you're going to review them now to ensure that they include the policies and procedures as they relate to COVID and a return to work in the presence of COVID. We make sure that the employees are reviewing them, signing off on them. We make sure that people, like at a golf course, and that's why golf courses have become very good at this, of saying to all of their members or anybody in the general public who's going to be golfing on that course, here are the rules that will allow you to golf. If you don't abide by those rules, you are not permitted to golf. And that will be visitors, that will be guests, that will be members, that will be people who are on site to fix the premises, contractors, all of that will be included, right? So that means that even in golf courses who have third-party contractors who are coming in to do certain work, and I know a lot of courses do, for example, if you're doing major work on the golf course, you might have a contractor come in to do it. I know years ago, you know, when the installation of a lot of reservoirs, those were third-party. If they're coming in right now, right, they have to be told that these are the policies you need to sign off that you will abide by these policies, so that if something happens to them, we can say we've advised our contractors on that. The training, this is all stuff that I've kind of just mentioned. So you inform them, you make sure they understand them, you stay current. All right, and those are all the things. Like I've given you a couple of suggestions in terms of, you know, how to ensure that they get the right training, including, you know, managing or staggering shift times, do being outdoors, which is not uncommon in your workplace. Maybe managing traffic flow with ground markings that show a visual cue so that they can see it immediately. Those are all very kind of simple and important things that you might want to do to ensure that they understand what the rules are and how we're going to impose social distancing. So just so you know, there is lots of examples of this, because since the pandemic started, there have been construction sites that have still been available and open and working. And constructors have made sure, or tried to make sure, that people working at the buildings or at the facility or at the site understand that social distancing, even though you're working, is still a responsibility. You can't get away with it just because we're on a work site. And they've already been doing this for months. All right, so it's very important. I can't stress enough that if there's personal protective equipment, there's a raging debate right now about whether it should be mandatory and whether it causes more harm than good, because when a lot of employees aren't trained how to take it off their face or how to take gloves off, and then they rub their face after they've infected their hands or possibly infected their hands. So I think you need to make sure that that's appropriate, but issuing personal protective equipment, particularly where you're going to be in common areas at meetings, I think is a very good idea. Gloves, which they'll have and have access to so that they can dispose of them where possible. Hand washing and sanitization cannot be underestimated. All right, from the very beginning, and I'm old enough to remember when SARS was around, that really was a huge, huge issue in the fight against SARS at the time, and is with COVID, which is keep your hands clean. And if you can't keep your hands clean, don't touch your face until you can keep your hands clean. So have the wipes, have the liquid. Make sure that public facing staff again are given hand sanitizer and that hand hygiene is promoted. And review these on a weekly basis to see how effective it is. Ask employees to give feedback on what they're seeing, what they're doing, if you could do things better. Communicate openly with them about it. It's the best way to find out if what you're doing is working. All right. The next step is to follow up. This is the supervision and monitoring. And this, quite frankly, in health and safety matters, is where most employers fall down. And I will tell you, because once you get everything in place and you've got your policies in place, when something comes down the road, and like, for example, in your case, the industry, you know, the course has been dormant for a number of months, and you're just going to say, well, yeah, you've got the same policies as last year and everything's okay. We would advise, and we did this in the case I was telling you about, that every year employees are coming back should have a training session, updated training on equipment. They should be provided with any diagrams, monitors, whatever it is, just to refresh them, to ensure that they understand that they've been giving refresher training and that you can say, we've done it, and supervise, right? Make sure that they're doing the right things. And if they're not, we don't need to fire them right away. We may not even need to, but we need to go up to them and say, look, our protocols are these. You're not following them. We need you to follow the protocols, right? Next time it's going to be a formal warning. We need to tell you right now that you've got to follow the protocols, or it's a problem. So make sure that they understand that. Monitor, supervise, and fix if required. That's a big part of this. Fix the problem if you see a problem. Don't let it fester. Don't let employees down the road to say, you know, I was with my supervisor or with the head pro and he saw me doing this and he didn't say anything, so I figured it was okay. That's a problem, okay? Now, it doesn't mean that the liability of somebody getting COVID is going to be that you're going to be sued for wrongful death or anything like that, or them being sick. because there are all kinds of issues with respect to that. But what it means is we want to make sure that the workplace is as safe and healthy as possible. And at no time is that more important than right now. But let's talk, this is a big one, because this is the right to refuse work. And I'm sure this has been on your mind for some time. The law is this: workers can refuse work where the conditions are likely to endanger them. All right, that's what the law says. The standard varies from province to province, but in Ontario, it can be a subjective belief, and they don't need to use explicit words all the time, saying, I am refusing to work because it's an unsafe condition and it's likely to endanger me. The Ministry of Labor gives very wide berth to actions or words that an employee might say, which should be constructively deemed to be a refusal to work by the employee. It creates issues because a lot of the times the employer says, well, I don't know you're refusing on that basis. If you don't do your work, go home or you're fired. And there have been cases like that. But where there's an employee who refuses to work, they have to, and they need to know that they need to refuse, that they need to report their refusal and the circumstances to the employer or the supervisor, who has to investigate. An investigation should take place of that refusal, and quite frankly, in many cases, if there's a joint health and safety committee, that's where you should involve the joint health and safety committee to ensure that the complaint is memorialized in the minutes, and so is the action on behalf of the company. If you decide that there's no hazard, but they refuse, they can report the refusal to the Ministry of Labor. I'll have something to say about that in a second, and an inspector will come in. The one key thing is you cannot dismiss, discipline, intimidate employees, or terminate if they've exercised their refusal in good faith. And there's all kinds of reprisal cases over the years that I've done where individuals have terminated because the worker said, well, I don't want to work, and the employer said, well, then you're fired. Or we've looked into it, there's no real hazard, you're fired. If it's a true personal belief and it's reasonable, they're protected. Now, I've done lots of cases where they were unreasonable and they just didn't want to work, and they were disciplined, and those were upheld too. It just depends, but you will not know unless you investigate or look into it. And that's why that's critical. If you look at the Ministry of Labor statistics recently, since the beginnings in mid-March, there were 83 work refusals, right? I think up to that point, 200 work refusals filed by workers who fear contracting COVID. As of mid-March, there were 83. So you can tell that, you know, we've had lots of employees who are refusing to return to work. If they make a complaint and want the Ministry of Labor to come in, I don't suspect the Ministry of Labor is going to have a lot of time to do that quickly. Okay, but they still have the right to say to an inspector, I want you to come in. I think I'm not being the workplace is unsafe. If that's the case, you gather when you're doing your investigation, you're speaking with the employee, and you've perhaps dealt with the Joint Health and Safety Committee. You gather all the information, your protocols, right? The posters, the information, the equipment provided to employees, the government directives with respect to the fact that golf courses can open, the health directives that say here are the best way to avoid contacting COVID. All of those things, and you say in the context of all of this, are you still refusing to work? Because we need to understand this refusal. And if they still do, they may be subject to discipline. However, you're in a bit of a bind because a lot of these employees you need right away to continue to do the work, particularly with the opening coming. But also, you know, you don't want to necessarily just terminate them. So you might say, that's fine. If you're not doing this, we'll allow you to take an unpaid leave of absence, go home, but we're not paying you. And that sometimes will shake them into coming back to work on a reasonable basis, okay? But that's very important that you understand that distinction. It's their right to complain. It's their right to refuse to do work. It will ultimately be tested more or less on the grounds of reasonableness. So when I'm saying, you know, a lot of what I've just said about the refusal to work is to be practical, right? There's the unpaid leave, right? If they're refusing to work on the basis of a human rights code protected ground, for example, they feel that they're sick, one of their relatives is sick, and they have family status obligations, that then clicks into that accommodation process that we talked about earlier on. And that means understanding the circumstances of why they can't come to work. And again, Just like if they refuse to respond to recall, you might be in a position where you say, okay, what can we do? You can, if you don't feel comfortable, we're going to address this, but for a period of time, you can go home and you can stay at home and it's an unpaid leave, right? If there's no medical issue, right, then it may be an appropriate, or family status issue. It may be appropriate to discipline. But I would avoid that if possible. Take the softer approach, at least right now. If you find that it's becoming endemic and a lot of people are starting to do it, we might need to take a harder line. But for right now, I would do it kind of communicative, find out, try to work with the employee and see if you can solve the issue on the ground rather than getting into a battle of words with employees. All right, so if I'm gonna give you some final thoughts on COVID generally, what I really do want to stress is none of us really know where this is going. We can say that we do, but we don't. So what we've learned from all of the authorities is that it's ongoing. There's a big debate on what the next steps are, whether it's to reintegrate or continue to isolate. You know, we hear of experiments from Sweden and in Europe where they're reintegrating large masses of population to see what happens, where schools are still open. We don't know, quite frankly. So follow your best practices on the best current medical advice. It's as simple as that. It's what our governments are doing. The exact same thing. So when you're dealing with employees, streamline communications, make them curt and effective. If you can have somebody at your facility that is designated to respond to COVID questions, much easier because they can ramp themselves up on the knowledge of the COVID situation. And it's one point of contact, so it's not one employee asking 17 different people at the facility and burning time. It's more efficient, it's better knowledge base, and employees will feel more comfortable going to one person. All right, you're going to get questions. You're going to get people who are acting irrationally. You're going to get members. You're going to get members of the public. They are going to act irrationally. You can count on it. All right. The question is, you know, I got a call from a colleague of mine in Michigan, where they had opened golf courses earlier on, and he said, you know, I'm getting all these kinds of emails from members who are saying right from the beginning, we want to get back on the course. They have no constitutional authority to do this, blah, 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 blah. Well, you know, this is right at the beginning of the pandemic when people were at the highest level of fear and they were saying, we got to get back on the golf course. So you're going to get people who are pissed off, going to get people who are irrational, deal with them logically. Communication is very, very much critical in these circumstances. Absolutely critical. Open communication. Answer questions when asked. Rely on information. Get the proper information. Make sure that your policies and procedures are in place and understood and signed off on. Manage your employee member public reaction. So, you know, I actually believe that we are going to learn a lot as employers and as a society as a result of this pandemic. We've learned better how to manage. We've learned how to manage in the absence of all the tools we're used to. We will continue to learn, and I think that's a big part of where we're going now. There's going to be mistakes, there's going to be backsteps, there's going to be errors. The key is to stay to your policies, stay where you are, keep current on your policies, and make sure that they're enforced, and we're going to be okay. It's going to work out okay. So I do have some, I don't know whether or not there are any questions. I know that Matt said he might sift through those. So Matt, if there are any right now, you can let me know.
Yeah, none so far. All some great content, some really nice takeaways that I think a lot of the people on can take away. If there are any questions, seeing a lot of you who are directly responsible for employment in your team. So any questions, feel free to type those into the chat box.
And if there's not, we can we can move forward. But if you have any follow-up questions, I'm happy to assist you, Matt, on dealing with your constituency. I appreciate. I do a lot of webinars. I do a lot of we did one on Tuesday, which was the return to working from home for employers, and we had 3,000 signups for that, just because It's such a burning issue for employers across the province and the country. And we're doing one on a return to work next week for general population, both clients and anybody who wants to look at it. So if you're interested in that, you can also sign up for that. Go to the Aaron Burles website, and you'll see an opportunity to sign up and register for that specifically.
Yeah, that's a great point, Lorenzo. I've sat on a couple of your firm's webinars, so anybody who's listening, I would highly encourage you to go onto their site and tune into anything that might be prevalent for you. So I'm seeing no questions pop up here. So Lorenzo, unless you have any parting words, I want to thank you for your time and all the great content. I know it's going to be very impactful and useful for our members, and let's get out golfing soon.
Absolutely. Looking forward to it. Thanks very much. Have a good season, everybody.
Thanks, Lorenzo.
Take care. Bye-bye.